Yes, start. Further, it is clear that notice in the present disqualification petition was issued by the Speaker only on 12/9/2018, long after the petition had been filed, and as correctly stated by the High Court, it cannot be expected that the Speaker will decide these petitions at all till the life of the Assembly of 5 years expires. In these circumstances, he has exhorted us to issue a writ of quo warranto against respondent number 3, stating that he has usurped a constitutional office and to declare that he cannot do so. For this purpose, he has cited several judgments of this court. He has also argued that though it is correct to state that whether a writ petition can at all be filed against inaction by a speaker in pending before a bench of 5 judges of this court, yet it is clear from a reading of paragraph 110 of Hulam versus Jacqueline and others 1992 supporting to SCC 651 that all that was by that judgment was the grant of interlocutory stays which would prevent a speaker from making a decision and not the other way around. For this purpose, he read to us Black's Law Dictionary on the meaning of a quatimate action and argued that the judgment read as a whole would make it clear that if the constitutional objective of checking defections is to be achieved, judicial review in aid of such goal can obviously not to be said to be interdicted. Full stop. He also strongly relied upon the observations of this court in Rajendra Singh Rana versus Swami Prasad Maurya 2007 4 SCC 270 and exhorted us to uphold the reasoning contained in the impugned judgment and then issue a writ of quo warranto against respondent number 3. Para. Mr. Madhvi Devan, learned additional Solicitor General, appearing for the Honorable Speaker of the Manipur Legislative Assembly, has argued that the reliefs prayed for in the writ petition filed by the appellant in the civil appeal arising out of SLP number 18659 of 2017 are diametrically opposed to relief for the writ petition number 353 of 2017, as a result of which they are being mutually destructive pleas and prayers made in the two writ petitions. No relief ought to be granted in the present case. In any case, the prayers asked for in the present case are directly interdicted by the judgment of a constitution bench of this court, in as much as a writ of quo warranto cannot possibly be granted without first deciding whether respondent number 3 stands disqualified, which is within the exclusive jurisdiction of the Speaker. She argued that the High Court was wholly incorrect in holding that the Speaker's decision under the 10th schedule would, would be in the nature of an alternative remedy and held that this would be directly contrary to several judgments of this court in particular. And Legislative Assembly 2016 8 SCC 1, which states that the Speaker has exclusive jurisdiction to decide disqualifications questions that are referred to him. In, in any case, she argued that a three-judge bench cannot decide the present case and has to await the judgment of a five-judge bench which has been made on a specific reference made by a two-judge bench of this court. She also distinguished the seat anchor of Sri Sibbal's case, that is, the judgment in Rajendra Singh Rana Supra, by stating that the facts there were completely different and that ultimately judicial review took place only because there was a final decision of the Speaker in that case. Further, because of the fact that the life of the Assembly was about to end, this court, using its power under Article 142 of the Constitution of India in an extraordinary situation, decided the petition for disqualification itself. Both these features are absent in the present case. Thus, according to her, while the ultimate conclusion in the High Court judgment is correct, all the findings in favor of the appellant fly in the face of judgments of this court. Full stop.